Thank you, Your Honor, and may it please the court, John Sauer on behalf of the appellants. This case involves a clear-cut violation of the statute of limitations and the law of the case doctrine. Last year in Trump 1 at 217 AD 3rd, page 611, this court held that no liability could be assigned for transactions that were completed prior to February of 2016 or 2014.
Mr. Sauer, that's premised on the fact that the statements of financial condition cannot give rise on their own to a new violation of 6312, right?
That is correct. That's what...
Then why didn't we say that in the earlier decision on the motion to dismiss when we were reviewing the motion to dismiss?
I think that's what the phrase, the continuing wrong doctrine does not apply to delay or extend limitations period means, because that is the continuing wrong doctrine. To say that like a 2017 or 2018 statement, is a new discrete wrong that's distinct from the original transaction that closed way back in 2012, that just is the continuing wrong doctrine.
You don't think it applies to Ivanka Trump's arguments on that appeal or to the Attorney General's now discarded theory that there was somehow a large amorphous fraud that somehow told the statute of limitations all the way back to 2011? Isn't that statement applicable to either of those two arguments made on the motion to dismiss appeal?
Your Honor, if I understand the question, the dismissal of Ms. Trump strongly supports our interpretation of the prior opinion because, of course, the allegations with her in the complaint are virtually identical to the allegations against the other individual appellants. So if you look at the complaint, you see virtually identical claims and theories as to those two. And once this court held she's not covered by the tolling agreement, she was completely dismissed from the case. The same should apply to anyone who's not covered by the tolling agreement here. And I would emphasize further, though, that there's really two errors here. Because even if the continuing wrong doctrine did apply, it still doesn't allow the trial court to do what it did, which is to go way back in time to 2011 and 2012 and assign liability and major consequences, huge financial consequences, based on an analysis that never looked at a 2017 or 2015 statement and said what liability flows from just that statement that comes much later in the course of conduct.
And loans which closed long ago.
Exactly right, Your Honor. And again, this court addressed this squarely in the Henry decision, which is cited in Trump 1, the CW Capital decision, which is cited in Trump 1. What Henry says is, even if you apply the doctrine, it only applies to allow liability for statements within the limitations period. But that's not what the trial court did here. That's not what the Attorney General's office contended. They said, we're going to apply the continuing wrong doctrine. That contradicts Trump 1, so that was the first error. But then the second error is, once we've done that, we're going to pretend there's no statute of limitations at all. And we're going to go all the way back in time and assign crippling financial liability for transactions that concluded again in 2011 and 2012. So there's a direct contradiction, a direct disregard of the prior, this court's prior opinion. It becomes really clear, I think, when you look at, for example, there's a citation of the Yin-Shing Lung decision by the trial court. And the trial court says this shows this is a continuous series of wrongs, each of which gives rise to its own liability, when there was an opinion from this court 3 months earlier saying the continuing wrong doctrine does not apply. That makes it very clear.
But again, shouldn't we have said, or wouldn't we have said, these statements of financial condition that fall within the limitations period don't give rise to a 6312 claim? Shouldn't we have just said that? Would saved everyone a lot of time.
I think that's clearly what the continuing wrong doctrine means if you apply it. And again, the dismissal of Ms. Trump strongly supports that. But in any event, Your Honor, even if the court doesn't agree with that, there's still a massive violation of the continuing of the statute of limitations. Because again, under Henry and versus Bank of America and under the CW Capital decision, the most the trial court could have done is looked at the 2017 statements and said, what liability can I assess to that? Can I impose that? And that is not at all what happened in the trial court. There was just a complete disregard of statute of limitations and an analysis that again and again goes all the way back to 2012.
Even if we agree with you on the statute of limitations point, that would not result in the complaint in its entirety being dismissed. There would still be several transactions that would be not time barred or timely. So what is your response to, or what is your strongest argument as to for dismissal of those claims, those exited non-time barred claims?
There would be 2 of the 10 that were charged in the complaint that we've identified that would only apply to those covered by the tolling agreement. Like Ms. Trump, if you're not covered by the tolling agreement, it's all gone, essentially. But in answer to your Honor's question, we argue that there was a complete failure of proof on the critical element of capacity or tendency to deceive, which is an element required of any 6312.
Well, I can stop you there. Are you talking about a failure of proof at trial?
Absolutely, Your Honor, as well as in summary judgment. So we raised this.
Okay,
with
but,
respect to
but
both.
cause of action number one, which is the fraud-based claim under 6312, liability on that was not tried, right? That was determined at summary judgment.
That is correct, Your Honor.
Okay,
And
so
so
I
we
don't-
challenge it as to both, yes.
I don't believe we can look at the trial record to answer any questions about the sufficiency of cause of action number one based on fraud. Don't we have to confine our review to the summary judgment motion record?
Well, to the extent that the trial court, in the final decision, was repeatedly referring to reinforce its prior holding in summary judgment, yes. Now, our position, of course, is that the failure of proof is even more defined, even more clear when you look at the summary judgment record. For example, just a couple citations to put this in context. Summary judgment record, page 13965 of the record, is a Deutsche Bank witness, uncontradicted, saying if his net worth had been as low as $1 billion, for example, he would have gotten exactly the same deal. It would have been exactly the same transaction. That's uncontradicted. It's reinforced by the trial testimony.
But could the trial court have credited Mr. Hayes' statement? He's also a Deutsche Bank employee, correct? And he said that if the facts were, if the SFCs were incorrect, then they didn't properly assess the risk on these loans. Mr. Hayes said that. You would say that in your brief, I believe.
He made a much more generic, if you look at that particular citation, he made a much more generic content that we want to make sure we're being, compensated for our risk. What is not disputed is the testimony that if the net worth had been as low as $1 billion, and again, this is the testimony of Williams, if the net worth had been as low as $1 billion, the deal would have been exactly the same. And so it's astonishing if you look at, for example, page 1882 of the record, which is their schematic that they cite 9 times in their brief, they concede that President Trump's net worth ranged between, on their view, $3 billion and $4.7 billion throughout this entire period, which is miles above.
If you're talking about summary judgment, isn't it basic that you don't make credibility determinations on the motion?
Absolutely correct, Your Honor, and we have a repeated violation of that, as we point out in our briefing. For example, there's sort of kind of astonishing credibility determinations to disregard unrebutted in the summary judgment record expert testimony. So if you look at 17916, the summary judgment affidavits of Bartoff, where he explains how all these representations, virtually everything they challenge, is consistent with generally applicable accounting standards. They're GAAP compliant statements. That's unrebutted in the summary judgment record. It goes beyond merely being disputed and you couldn't decide it by a credibility determination. There's really nothing to the contrary. And again, these errors are all reinforced at trial, so we are challenging both of those. And if you look particularly at Professor Bartoff's testimony, you have this clear explanation that all the things that they say are misleading are things that are specifically approved in ASC 274.
Creating an issue of fact, correct?
Exactly right, Your Honor. That's exactly right, Your Honor. That's at the very least, that's a disputed issue of fact. It isn't just Professor Bartoff. There's a whole series. There's Professor Flemons. There's a whole series of experts. When you get to, yes, Your Honor.
Well, you finished that, but then I have a question for you about the scope of the statute.
Go right ahead, Your Honor.
Okay, yeah. No, so just looking at the language of the statute, it says that it's enacted to promote the honesty and integrity in commercial marketplace in New York by stopping fraud and illegal business. So to accomplish this, the statute authorizes the Attorney General that whenever a person shall engage in repeated fraudulent, I know that you're challenging that, or illegal acts, that they can bring such an action. So why isn't the language of the statute here referring to the repeated and fraudulent illegal acts or persistent fraud or legality? Why doesn't that define the scope of the statute? Why do we need to go to harm or threat of harm?
Yes, Your Honor. So the standard is that, as this court held, for example, in General Electric, is there has to be a capacity or tendency to deceive or atmosphere conducive to fraud. And what we've pointed out is that you have a situation where there were no victims, no complaints, no evidence of causation, materiality, or reliance. There were sophisticated counterparties who, the understanding of the relevant marketplace, as this court said in the Nordbank decision, understood that they would be doing their due diligence. They did do their own due diligence. The uncontradicted testimony in the summary judgment record is everything we did was independent. We didn't rely on the numbers. That's the Williams testimony in the summary judgment record. All that is evidence, for example, the Domino's Pizza decision that we've cited powerfully makes this point, where all of that is lacking. All that is powerful evidence that there was no capacity or tendency to deceive, which ties into our point that every single
What about
one of
the
these
issue?
transactions would have exactly the same.
I'm sorry, counsel. What about deterrence? In other words, the AG would have the argument that maybe these deals went down fine as far as all the parties were concerned in these deals, but in the future, some deal might not go down well and someone would be harmed by that. And so we need to deter parties from putting in, fallacious statements of financial whatever. Good.
May I respond?
Yes.
Red light. Just to answer that question, the deterrence interest goes entirely the opposite direction, where we have a situation where the Supreme Court disregarded unrebutted expert testimony that these are GAAP compliant. These are consistent with accounting standards, which don't require perfection.
No, but the Attorney General points out that whether or not they're consistent with GAAP principles, it's the factual inaccuracies that are important. So in other words, you might be following GAAP principles, but if your data is terrible, then you're creating a fallacious statement.
Respect to that completely that disregards or at least misinterprets our expert testimony, which look at what they say is factual data that's misinterpreted. For example, appraisals. Essentially the Supreme Court said if you got an appraisal in your file, you got to rely on that. You can't rely on your own independent judgment. They say that's a factual inaccuracy. GAAP says the opposite. At least that's the unrebutted testimony in the summary judgment record. And I would direct the court to page 17916, the beginning of Professor Bartov's summary of opinions on that.
I want to turn your attention to a different subject because your red light is on. I'm trying to figure out about the valuation of Mar-a-Lago. I noticed that your expert, Mr. Mons, valued it at over $1 billion. He also said that if it was in the hands of a new owner, club memberships, 500 club memberships could be sold, generating $250 million. And it generates revenue of over $50 million a year in 2022 and 2023. And Supreme Court values it at $18 to $27 million because of restrictions.